Good day and welcome to the U.S. Chamber of Commerce webinar on the DOL Overtime Rule conference call. Today's conference is being recorded. At this time, I would like to turn the conference over to Mark Friedman. Please go ahead, sir.
Thank you so much. Good afternoon for those of you on the East Coast. Good morning for those of you further west. Thank you for joining us on this webinar to discuss the new overtime regulation and how employers can comply with it. We have had an overwhelming response on this, so we're very gratified that all of you have decided to participate. I'm not going to spend a lot of time. I want to introduce my boss, Senior Vice President for Labor, Immigration, and Employee Benefits, Randy Johnson, here at the U.S. Chamber, who will give some remarks and then introduce our speaker, Tammy McCutcheon.
Hey, thanks, Mark. And we had over, as Mark said, 1,000 people register for this, which could, I think, very well be a record or close to a record here. So some of you, a few of you may not actually be familiar with the United States Chamber of Commerce. And I just want to mention, at least there be any confusion, that we represent the employer community here in Washington, D.C. and across the country. We represent the interests of more than 3 million businesses of all sizes and sectors. And we've got a huge network of state and local chambers across the entire country, and including something like 500 business associations and 116 American chambers abroad. Contrary to a lot of popular perceptions, close to 96% of our membership are, in fact, small businesses, who I'm sure many of you are on the phone today. We set policy here at the Chamber through a lot of policy committees. Our next speaker is on our Labor Policy Committee. But I like to tell our members and those who aren't members that we as staff don't set the policy here at the Chamber. We're driven by those of you out there beyond the Beltway in the real world. And we listen to our members in trying to figure out how do we best approach many challenges here, including decisions about which regulations are the worst, which ones do we go to Capitol Hill on, which ones do we go to court on. Now, there has been a slew of regulations coming out of this administration. Well, slew is too big of a word, but it's about 5 or 6 or 7 of very troublesome regulations, ranging from the one we're going to talk about here today, a new one on OSHA record keeping, some in the National Labor Relations Act areas, and of course some case law that we're troubled with that we're not going to talk about here today. But my point is we've got our challenges. We recognize that. I want to assure those of you who are on the phone that although many of these are moving to final regs, we're not giving up the fight on these. We're still looking at possible relief up on Capitol Hill and also in the courts. I also want to mention before going to our next speaker that there's a lot of stuff that we managed to bury over the last 7.5 years of this administration in the agencies and never saw the light of day. So things could be worse in many ways, but that being said, we fully recognize that many of the things coming out of this administration, as it winds down, are in fact going to make your lives very, very difficult. So we're going to continue to push back on those, but while we're doing that, we're also trying to offer to our members services to provide a primer on how to comply with the regulations, while at the same time we're going to try and still beat them in other forums. And in terms of helping you comply, we have today Tammy McCutcheon, who was the past wage and hour administrator under the Bush White House in the Wage and Hour Division, knows the Fair Labor Standards Act better than probably anybody else in the entire country. More importantly, not just in a theoretical sense, but Tammy is super great, and I saw her speak to my Small Business Committee in providing helpful tips to companies on how to comply. And so when things move from the theoretical to the more practical, Tammy's the best guidance you could have. I do want to note that this is a conference call. This is a webinar for people in the employer community, and that it's closed to the press. That being said, I suppose we're never going to know if there's someone from the press and they stay on, but if you are from the press, we'd ask you to get off, to be frank. Now with that, let me turn it over again to Tammy again. Tammy, thank you for your time. I know you're overwhelmed with inquiries in this area, but you're our hero, and you did our conference for the Chamber. And go start off with your PowerPoint, and then we'll go to Q&A.
Great. Well, thank you, Randy, and I've enjoyed working with you for the last 2 years as we've tried to influence this rulemaking. And over the course of today, I will talk about how we indeed did influence this rulemaking. In fact, in its final rule, the comments that Randy, Mark, and I wrote on the DOL's proposed changes were cited and quoted and mentioned over 80 times, which was more than any other commenter. So we have had an impact. And there is some good news about the final rule, although, of course, the final salary level of $47,005, which we'll talk about in a few moments, is still way too high. I'm sure most of our audiences will agree. So I'm going to start with just a quick backgrounder on the FLSA, go to describing the changes in the final rule that you'll need to comply with, and finally talk about the different steps I think you need to take to make sure that you are preparing to comply with the regulation by the effective date, which is December 1st. So first of all, of course, the FLSA. The FLSA is, of course, the law that requires payment of the minimum wage and overtime. However, since 1938, when it was passed, there has been an exemption for white-collar employees in the FLSA, and that's for bona fide executive, administrative, professional, and outside sales employees. There's no definition for these terms in the statute itself. Instead, the statute says, and I've quoted it on the slide there, as such terms are defined and delimited from time to time by regulations of the Secretary subject to the provisions of what we call the Administrative Procedures Act. That's the act that requires the Department of Labor to issue a proposed regulation and give stakeholders, including organizations like the Chamber, an opportunity to comment on those regulations. DOL has defined the regulations in 29 CFR Part 541. They're sometimes called the white-collar regulations. They're sometimes called the EAP regulations for executive, administrative, professional. This section of the regulations also includes requirements for a computer employee and outside sales exemptions, but neither one of those categories are affected by these regulations. There's no changes to the outside sales, and the salary level does not impact the outside sales employees. It also doesn't impact teachers, doctors, and lawyers. Under these regulations, the Department of Labor has 3 different tests that you have to meet, as the employee has to meet in order to be classified as not eligible or exempt from the FLSA overtime requirements. First, you have to be paid on a minimum salary level, a salary threshold. Second, that salary has to be guaranteed. That's called the salary basis test. And what the salary basis test says is that an exempt employee must receive their full salary for any week in which they perform any work. In other words, you cannot dock the salary of an exempt employee because because of problems with their work performance or because of the number of work hours they work. This, to me, is the quid pro quo between exempt and non-exempts. Exempt employees don't get paid more for working over 40 hours, but you also can't dock them if they decide to take a 2-hour lunch or they go home early on Friday, whereas non-exempt employees, overtime eligible employees, are only paid for the hours that they actually worked. Finally, for each category, executive, administrative, professional, there is a set of duties tests, job duties that to be classified as an exempt executive or a people manager you have to meet. In this rulemaking, DOL has only made changes to the salary level test for exemption and not to the salary basis or the duties process. So as I mentioned, the shoe has been hanging over our heads since 2014. It all started in March when President Obama directed Secretary of Labor Perez to revise these overtime regulations. During the summer of 2004, I accompanied Mark and Randy in the Chamber to the Department of Labor, and we met with Secretary Perez in what he called a listening session. Although I'm sure Randy and Mark will agree, he didn't seem to listen to us too much then because the proposal included many things in it which we had expressed to Secretary Perez that we felt would be harmful to business. Then we got the proposed regulations last summer, July 2015. we only had 3 months, 90 days to file our comments on it, which was a very, very short time for such a major regulations. And thousands of people asked DOL to extend that time for comment, but they declined to do so. Nonetheless, we worked really, really hard and got our comments in, which I'm not being immodest in saying. We're very substantive with a fantastic economic analysis by the Chamber's Chief Labor Economist, Ron Bird. I think we were like 200 pages long in 90 days, and even for a lawyer, that's an accomplishment. Then in March of this year, March 2016, DOL was finished with its draft, and it sent them over to the White House's Office of Management and Budget for a final review. The White House OMB is really the agency that has the final sort of red line, right? They're the final editors of any regulation before it's approved for publication. And of course, I accompanied the Chamber to a meeting over at OMB to discuss what we liked and really didn't like about the proposal, and to state again our objections to some of the Department of Labor's proposal. And then, of course, last week on May 18th, we got the final rule. And here we are today to talk about the final rule and what it is. Just a brief review of the comments that the Chamber filed and made, because I think it's important as we look at what's in the final rule. We acknowledge that that some increase was time for. The salary level had not been increased since my watch in 2004, so it had been over a decade. However, we, of course, said that $50,000 was way too high, and suggested a number of alternative methodologies for determining the salary level, which would have ended us up somewhere between $30,000 and $35,000, but nowhere close to $50,000. We also suggested a 3 to 5 year phase-in if they were going to raise it that high. We supported the Department of Labor's proposal to count bonuses towards meeting that minimum salary level, but also told DOL that they should count commissions and that they should count quarterly bonuses and annual bonuses rather than just bonuses paid monthly or more frequently as proposed. We strongly opposed their suggestion that we have annual automatic increases, and we objected to any changes at all in the duties tests in the Chamber's comments. So now, with that in mind, let's take a look at what the final rule actually says. First of all, what's not changing? No changes, as I mentioned, to the salary basis test. And no changes that impact outside sales, teachers, lawyers, or doctors, and no changes to the duties tests. And I can't, you know what, Mark and I were betting whether they would do changes to the duties tests, and I'm glad that I lost that bet, Mark, because I thought they would do it. I mean, I haven't seen this administration restrain itself on anything in terms of regulations, but they did not make any changes to the duties test, which is a really big win for employers, I think. Because their proposal was basically to change the federal duties test so it tracked the California rule that required employers to prove that their exempt employees spent exclusively 50% or more of their time performing exempt duties. And that would have been very, very difficult. That test in California has generated so much litigation. It's so hard to implement, and now we don't have it. And so I'm very happy that they listened to the Chamber's comments in not making changes to the duties tests. But of course, we do have an increase to the minimum salary level, and it's still, even though the Department of Labor knocked down their proposal $3,000, which for all of you, you know, it's the difference between $50,440, which was the proposal, and $47,476. Here's my other complaint: can't they just make it $47,400 or $47,500? How are we all going to remember $47,476 or $913 a week? That's the new salary level. It's almost 100% double of the existing salary level of $455 a week or $23,660 annualized, which I adopted in 2004. But as I said, down from DOL's proposal of over $50K. What this minimum salary level means, of course, is that every employee in America who earns less than $913 per week or $47,476 annualized must be paid overtime. The department got to this level by setting it at the 40th percentile, as shown in BLS data, Bureau of Labor Statistics data, of full-time, non-hourly paid employees in the lowest wage census region, which they identified as the South. Now, some of you, like me, might have been puzzled. Really? 40th percentile in the South is $47,500? When we set that 23,660 in 2004, we also looked at the same BLS data set, but we looked at data from southern states and from the retail industry to get, and we only used 20%. We didn't use 40. And we, in our comments for the chamber, we said, listen, that 5440 was based on a national number, and we criticized that in our comments and said, first of all, you shouldn't use 40%, you should use 20, and second of all, you shouldn't use national numbers because this salary level has to work in rural Midwest and southern states. It has to work as well in New York State as it does in Louisiana. The interesting thing about they use the census region. Guess what states are included in the census region in the South? It includes Maryland, Virginia, and the District of Columbia, which in this area here where we're in, where Mark and Randy and I are in today, I hate to tell the folks in DOL, this is among the highest earnings in the country because of all of the federal government employees and their nice paychecks that they earn. So even though they said, okay, we're going to look in the South, they really didn't look in the South because their data set that they're looking at includes data from the mid-Atlantic states, which are, believe me, people in the D.C. metro area earn a lot higher salaries than folks do in Biloxi, Mississippi. So we're still too high, but that's what you have to get to by December 1st if you want to maintain the exemptions. You want to still not pay employees overtime. You got to get to that $913 per week. All right. There is some good news on the bonus and commission side. As I mentioned, DOL had proposed that we could count certain bonuses paid monthly or less frequently for up to 10% of that minimum salary level. In our comments for the chamber, we said, well, you ought to count commissions too. You ought to count quarterly and annual, and it should be higher than 10%. The DOL gave us some of what we asked for. Commissions will count in addition to bonuses, and you can count commissions and bonuses that are paid quarterly or less frequently, but not annual. So that's one thing you can do is start changing all your annual bonus plans to quarterly bonus plans. And they kept it at 10%, so about $5,000 a year in bonuses and commissions can count towards that minimum salary level for exemption. So how exactly is all of this going to work? It's a little bit complicated. But here's the deal. Each work week, as an employer, you must pay the exempt employee a salary of at least 90% of that minimum $47,500 salary level. In other words, the minimum, what employees need to receive in base pay in their paychecks as salary is $821.70 a week. That's 90% of the $913. Then you pay them their bonuses and commissions quarterly, monthly, biweekly, weekly. And at the end of the quarter, if that base salary of $821.70 plus all of the bonuses and commissions they've earned during the quarter are not equal to $11,869, 1/4 of the minimum salary level, then you need to do a makeup payment for the shortfall. And you have to do that in the first pay period after the end of the quarter. So you have one pay period to pay your last bonuses and commissions and make sure that for the quarter as a total, the employee got $11,869. So that's a lot of work administratively, whether it's worth it to you to be able to count, a little under $5,000 in bonuses and commissions towards that $47,476 will be up to you. But this is how it's going to work. Now, one question DOL did not answer is what about employees who leave in the middle of the quarter? We really don't know. because, of course, DOL didn't tell us that this was how it was going to work in their proposal. But what I'm recommending is that if an employee leaves in the middle of the quarter and you're trying to use this 10% add-on, then what you ought to do is go back as they're leaving and make sure that for each week in which they actually worked in the quarter that they got the equivalent of $913 per week, which means you might need to make that make-up payment in their final paycheck as they're leaving out the door. Now, why would you want to do that? You'd want to do that because of the consequences of failing to comply with the salary test is that not only that employee who left, but any other employee who you're treating similarly under a similar policy, you could lose the exemption for them. So as employees that you're treating as exempt are going out the door, and if you're using this 10% method, please make sure that they leave your employee having earned $913 per week in each of the weeks in a partial quarter. That is the best approach at this point, pending additional information from DOL, which we will probably never get. The Department of Labor also increased the total annual compensation that an employee needs to earn to be considered a highly compensated employee. The advantage is, of course, that highly compensated employees only have to meet a very minimum, very reduced duties tests. There's almost a presumption that if you are a highly compensated employee, you perform exempt duties, and so it's just a peace of mind thing. You don't have to worry about employees treating them as exempt if they're white-collar employees who earn above the highly compensated level, which is going from $100,000 currently to $134,004. Now, why couldn't they just say $134,000? So make sure it's $134,004. That is the 90th percentile of full-time non-hourly workers nationwide. We will also see, and it says automatic annual increases on the slide because that's what the Department of Labor proposed, to increase those salary levels, both the minimum and the highly compensated salary levels every year. We, of course, objected to any sort of automatic increases to the salary level. The Chamber feels that if there are increases in the salary levels, there should be an opportunity for notice and comment rulemaking every single time it's changed. But the good news is that they did modify a little bit. We are now going to see automatic increases to the salary levels every 3 years, with the first one beginning will be on January 1, 2020. So how is that going to work? Well, DOL is by regulation will have to provide us notice of the new salary levels 150 days before January 1st. And that notice will come both in the Federal Register, and since I know none of you are out there every day reading the Federal Register, why would you? It will also be posted on DOL on the Wage and Hour Division's website. The URL is on your screen, www.dol.gov/WHD. But probably the information, if you're members of the Chamber, I'm sure the Chamber will be sending out notices when we get around to getting one of these automatic increases. So you'll have to keep your eye out and look for every 3 years. So in October, November of 2019, you'll want to keep your eye out for the new regulations. The new levels will be set at the 40th and 90th percentile as the salary levels were set in this regulations. A question that I have is, what happens if salary levels are stagnant or go down? Will we see a decrease in the salary levels if there's some problem with the economy and salary levels go down? And the way I read it, I quoted it in this slide, the regulations say that the minimum salary level will be updated to equal the 40th percentile. So there is, I think, some wording in the regulation that indicates that if the 40th percentile for some reason goes down, that the salary level would have to go down too. But I wouldn't hold my breath for that. I don't think it ever actually happens. But at least it's interesting that they wrote it that direction, which they did not do, for example, in their regulations regarding minimum wage for government contractors, which can only go up in that regulation. The effective date is December 1st, 2016, but I do want to remind everybody in our listening audience today that there are state laws out there that require employers to provide notice to employees if you're going to make changes in pay. And so that really does mean that the effective date is not December 1. December 1 is when you need to actually implement changes, but you're going to need to give your employees notice about the changes that are coming to them before that. Now, some laws are only require notice for decreases in pay, but if you're reclassifying employees, if you're switching them to hourly, it'll be very hard to determine whether how the changes will impact them. Will it be a decrease or will it be an increase? So my recommendation is to look to your state laws and comply with the notice requirements. Most states require only 7 days or 1 pay period's notice. The longest is Missouri, which requires 30 days notices for reductions in pay. There's also DOL, at the same time as they put out this rule, they put out a non-enforcement notice for healthcare employers small healthcare employers who provide Medicaid services in facilities with 15 beds or less. And they said to this group that, don't worry, we're not going to enforce this provision until March of 2019. And I also, if anybody in our audience happens to be one of those employers, don't listen to DOL. You still have to comply by December 1st, because even if DOL decides not to enforce this rule against anyone, it's still effective on December 1st, and your employees and their attorneys can still sue you regardless of what the Department of Labor will do. So if anybody says, oh, they're not going to enforce it on December 1, let's not worry about it, ignore them. Because the employees and the plaintiff's lawyers are out there, and the plaintiff's lawyers, believe me, are waiting for employers to be late in their compliance so that they can file collective and class action lawsuits. Okay. How am I doing on time? 12:31. Okay, we're doing pretty good. Now, so that's it. Salary level 47 and 476, increasing every 3 years, but you can count bonuses and commissions. Let's talk about what I want to talk about next is two things. First of all, question I get all the time: is this really going to happen on December 1st? Do I really have to comply by December 1st? Is there a path to stop or modify the rule? There is still activity going on, right? In March earlier this year, in March, Senate and House Republicans did introduce the Protecting Workplace Advancement and Opportunity Act, which would nullify the final rule and send the Department of Labor back to the drawing board and completely prohibit these automatic salary increases every 3 years. Of course, even if the Republicans managed to get that through the House and the Senate at this point, President Obama would veto it. And, of course, we're not going to have a new president before the effective day of December 1st, so you really can't rely on that. I suppose there's a chance to put this language in an appropriations bill and make President Obama veto it in order to save this overtime rule, but I'm just not, I don't know. I don't hold out that much hope for that. There's also something called the Congressional Review Act, and under this act, a joint resolution of Congress passed within 60 legislative days of the final rule and signed by the president can also invalidate the rule. But most people think that the Department of Labor published these regulations in time so that the 60 legislative days remaining in this session will expire before we get the new administration. Just think about that. There are less than 60 legislative days which your Congress will actually be in session here in Washington before the election and the end of this congressional term. I think that's sort of funny, but it is an election year. President Obama, of course, if it was passed in this term, would veto it, and there's unlikely to be days left over in a new administration. So again, the Congressional Review Act is not really not much hope. But there are two things I think that are more hopeful. First of all, will there be a litigation challenge? And there are arguments out there. There are possible challenges, especially to the automatic salary increases. And I've also been talking to folks about developing arguments to challenge the salary level as just being so high that it's contrary to congressional intent. So we are we're talking. People are in the business community are talking about a possible litigation challenge, and I think there'll probably be a decision on that within the next couple of weeks. So keep your eyes and ears open. It might happen. It's not an easy case to win, but it's also not an impossible case to win, and so you might see a complaint filed sometime in the next month or so, challenging the final regulations. However, even then you got to get that salary level stopped by a court before December 1, and that's another challenge. And so I would not hang my hat on litigation. I think you need to start preparing nonetheless anyway, because you never know what's going to happen in litigation. Finally, if there is, I used to, when I'm giving this presentation live, and I can't, of course, hear you or see you out there, but I used to say, an incoming Republican administration could redo all of this, and the whole room would laugh at me. But, of course, last week we saw that Donald Trump is leading Hillary Clinton in all the polls, so who knows? And a Republican administration can basically restart the regulatory process and do a new notice of proposed rulemaking, and look at everything again from scratch in a new administration. I think it would take a lot of political courage to walk down from that 47,000 level, but I am certain that a new Republican administration could, at the very least, stop the salary increases every 3 years. So I guess my bottom line here is you have to comply by December 1st or face being out of compliance with the Fair Labor Standards Act for your exempt employees. And so, my advice is don't assume these are going away. Start right now in determining who you're going to reclassify and how you're going to come into compliance with these rules. My experience helping dozens and dozens of employers reclassify employees from overtime eligible, non-exempt to exempt. Other way around, exempt to non-exempt. It does take 6 months to do, and DOL has given us until December 1st. By the way, we went to the White House OMB with the chamber. We told them over and over. We would spend a lot of time talking to them about how long it takes an employer to switch employees from exempt to non-exempt, and I told them it takes 6 months. Well, they gave us almost 7 months, and so we have until December 1st to come into compliance. I think that is a big win for business, that we got you that much time when the talk out there was, and this is legally, DOL only had to give us 60 days. Now they're giving you 200 days, and that's a big win. So, but don't wait just because it seems like a long way from now. December 1st is going to come before you know it, and don't forget about those state notice laws. So don't wait. Get started on planning for compliance now. And I want to spend the rest of my time basically taking you step by step through all of the decisions and issues I think you need to think and talk about and make decisions on in order to comply. First of course, you have to identify employees who you're going to give salary increases to maintain the exemption versus you're going to reclassify them as non-exempt and start paying them overtime. Once you identify the employees who you're going to reclassify and start paying overtime, you have to develop and think about how you're going to pay them. You probably don't want to continue paying them on their current salary and just add overtime unless you happen to have extra piles of money sitting around that you can give to your employees. I'm going to assume today that most of you don't, and most of you will want to maintain your labor costs. And so we're going to talk a little bit more about how you can do that. It's also a really good time to review your wage and hour policies and processes, in particular timekeeping, as you will now have a big group of employees who've never had to track their time before, and you want to make sure that you get that done correctly. You'll need to communicate the changes to the employees who are being reclassified, and that is going to be a very delicate process because I think most of you on the phone today in our webinar today will agree that a lot of employees are not going to like having to start punching the time clock and tracking their time and having their work more closely supervised. Finally, I do recommend that you train both the employees you're reclassifying and their managers, and we'll talk about all of these one by one in the next, I'm going to try to stop for questions at 12:50. Okay. So first, identifying jobs for review. Obviously, you want to pull out all the jobs that you currently have classified as exempt from overtime below that 47 3476 annual salary level, but also consider that 10% counting of bonuses and commissions means that employees who earn $42,728.40 annually with $4,747.60 in bonuses and commissions a year. Also, you can keep them classified as exempt without having to reclassify. It's also a good time right now, even if salary level isn't an issue. I think a lot of people out there probably know they've got some classifications that they might currently not be classified correctly if you're still treating paralegals or help desk employees or inside sales employees or entry-level accounting employees as exempt from overtime. That's probably not compliant with the current law. And since you're going to have to make changes anyway to how employees are paid, it's a real good time to consider job duties too and look at the employees and their job duties and make sure they do qualify for an exemption, a white-collar exemption, even apart from what's happening in the changes to the regulation. Okay. So I think I've got slow in it. There it is. So the first choice is salary increase or overtime. So for that, pull salary data and pull your incentive data, your bonuses, your whatever you do, profit sharing, production bonuses, sales bonuses, commissions. And you're going to need to compare the cost. How much is it going to cost to increase the salary level versus how much is it going to cost you to pay overtime? In order, of course, getting people from they're currently paid $40, and so it's going to cost you $7,476 to give them a wage increase to maintain the exemption. That's a pretty easy calculation. Calculating the cost of what overtime will be for you is a little bit more complex because what you really need to do to calculate that is to have an accurate picture of how many hours you expect them to work. Now, for example, if you have employees who don't work much more than 40, it's probably going to be cheaper to reclassify them as non-exempt and pay them overtime for those few hours of overtime. On the other hand, if you have employees who are working 45, 10, 15 hours of overtime every week, it might be actually less expensive to give them the salary increase. So you need to go out and do some research. You can ask the managers, you can ask the employees themselves, how many hours are you working each week? And set your own expectations. How many hours do I want them to work each week? How many hours can I manage to each week? Can I manage to 40, or do I need these employees to be working 45? Once you get the number of expected hours, you can put it into the formula that's on the screen to figure out how much the additional overtime would cost if you continued to pay them their current salary level and they worked more than 40. However, there is a cost-neutral solution. You can reclassify employees to hourly and select an hourly rate that will get you to the same weekly compensation as the employee is earning today. And then, of course, the same annual compensation. That formula is on your screen. You take their weekly salary divided by 40 hours plus the number of expected overtime hours times 1.5. Because for every hour over 40, you're going to pay them for an hour and a half. That's the overtime, the 1.5 of overtime. So, for example, if you have somebody who you expect to work 50 hours a week, take their current weekly salary and divide by 55. And the resulting hourly rate will result in the same total weekly and annual compensation as you're paying them today. Yes, it's legal. I got in trouble in 2003 when we put this in the preamble to our notice of proposed rulemaking. The New York Times just raked me over the coals for this, but it's in there. It's perfectly legal. I put the citation in the slide. You can read about this at 68 Federal Register 15576. So this, if you want to, the best way to make sure your labor costs do not increase is using this formula. Okay. I did want to bring your attention that we actually have an app for that. It's Compliance HR is a company that I'm a vice president of. It's a joint venture between the Littler Law Firm and a technology company called Neotologic. And in this application, you can put in information about your salary, your bonuses, your commissions, and it's going to give you all the three numbers we talked about today. How much it's going to cost for the salary increase, how much would it cost to maintain the salary and pay overtime, and what is the cost-neutral hourly rate. The URL is on your screen. This is a free app, so you can go into it today and run some of your employees through it and find out what is going to be the best solution for you and your company. Just a tiny bit about the job review process. If you want to look at job duties to determine whether or not that an employee actually meets the job duties requirements for exemption, please do this with an attorney, whether it's inside or outside, because you want to keep it privileged so that those plaintiffs' lawyers can't get a hold of your analysis. You want to look at information, data that you have about the employees, for example, the number of direct reports they have to analyze the executive exemption, what their educational degrees they hold to analyze the professional exemption. You also want to review any job descriptions, training materials, process manuals, any documentation you might have that describes the job duties and documents the job duties that are being performed by the employees. But you really need to do is sit down with managers who are familiar with the jobs that you're going to be reviewing and ask them, what do employees in this job do? And then, of course, you need to consult with an expert, whether it's an expert HR, but probably better, so it's privileged, a lawyer, to analyze whether or not the job duties performed by the employee actually meets the qualifications for exemption. And of course, I have to tell you that Compliance HR has an app for that too. And what this app does, this one, sorry, I can't give away for free, but it's very moderately priced. And what you do here is you have somebody fill out an online questionnaire, just like a SurveyMonkey questionnaire, about an employee's job duties, and it will give you the final report you see on your screen, telling you what the risk is of classifying this particular employee as exempt or non-exempt. Two resources that you can use, both to use very quickly, internet scale and speed, to get your house in order and come into compliance with these new regulations by your December 1st date. So now you've got your list. These are the employees that are now exempt. I'm not paying overtime, that I'm going to reclassify to pay overtime. That is a big decision, maybe the hardest decision, but you have lots of other things to consider as you implement the decision to reclassify them. The first thing, of course, is their compensation plan. Are you going to continue to pay the employees on a salary? And pay overtime after 40 based on the salary? Or are you going to convert them to hourly? Converting them to hourly might be the easiest, but there's options for salary too. You can pay non-exempt employees on a salary. In all states, if you do that, you can determine their overtime pay rate in a number of different ways. All states allow you to take their salary and divide by 40, and that's what the Cost Estimator app does. But in all except for 6 states, California, Pennsylvania, Alaska, Hawaii, New Mexico, and Connecticut, you can also calculate overtime pay for exempt salaried employees by dividing by the actual hours they work each week. That's going to save you money because the more hours an employee works, the lower their overtime pay rate will be, because you're dividing 913 by 50 hours rather than 40. There's also something called the fluctuating work week. You really do need expert attorney advice to implement the fluctuating work week plan. But what you do for the fluctuating work week is you agree with the employee that their salary is their straight time pay for all hours they work, whether that's 30 hours in a week, 45 hours a week, or 60 hours a week. Their salary is always their full straight time pay. What that means is for hours over 40, you only owe an additional 0.5, not an additional 1.5. So this is a 2/3 savings in your overtime costs. But because it's got such great advantages, there are requirements you need to meet. You need to have a written agreement, preferably with your employees, that sets forth the expectations that their salary is their straight time for all hours worked. It doesn't work in those 6 states I mentioned, but it is a tremendous savings and something you might want to consider. The other things you have to consider, for the reclassified employees, are you going to continue to provide them with bonuses, incentive pay, profit sharing, stock options that they're receiving right now? What you should know is If you pay those types of compensation, any type of incentive pay to non-exempt employees, you're going to owe overtime on the incentive pay. Don't forget FLSA, no good deed goes unpunished. So if you decide to continue to pay a profit-based, sales-based, revenue-based bonus to a non-exempt employee, it's going to be more than you think, because you have to calculate the additional overtime that was due based on the hours worked during the bonus period. So again, really consult with your outside attorney or another expert to make sure you're properly calculating overtime pay on the bonus. You also need to think about any other benefits. If you have different, more generous benefits for exempt versus non-exempt employees, you'll have to determine, and that could be better vacation pay, better paid sick, better short-term disability policy, company-paid life insurance. You need to go through all of the benefits and determine which ones are the reclassified employees still going to get. And if I want them to still get them, do I need to go back and change the eligibility requirements in my benefit plan? Particularly important, of course, if it's an ERISA qualified plan, to make sure the eligibility requirements are properly written. It's time to review your wage and hour policies and processes, particularly because you're going to have a group of employees who've never had to track their time before, who've never had to worry about taking a state-required meal break. You're going to have employees who are used to bringing smartphones and laptops at home and working from home. So you need to have good policies letting them know that that is work time and that they need to record it. You need to have policies that tell your managers you cannot allow or require employees to work off the clock. My one fear for employers, my biggest fear, is I think you'll be able to deal with the salary level increase one way or another because I've given you that cost neutral solution. But my big fear is that you don't succeed in tracking all of the hours worked by these reclassified employees, because one of the most popular lawsuits out there is what we call the off the clock work time. Right? An off the clock claim, the employee comes in and says, well, I was working at home and I didn't get paid for it. Or I worked through my unpaid lunch period and I didn't get paid for it. So you really do need good processes and policies to make sure that the employees are on the clock, are recording their time when they're working away from the office. Travel time is a good example, right? You know, with an exempt employee, you don't worry about the time they spend traveling because you don't pay for it separately. Now you have to. So you have to consider, am I going to let non-exempt employees go to the conference in Florida this year? Or God forbid, the conference in California? If you send a non-exempt employee to a conference in California, not only do you have to pay for the travel time, not only do the hours count towards the 40, but you have to pay the employee while they're in California under California law. So you really have to consider, how am I going to pay for? Am I going to allow them to travel? Am I going to, and how am I going to pay them for that travel time? Finally, you got to communicate the changes. And you know, this one, I think there is some help from the government. My key advice is blame it on the government. It's not your fault. You're going to have a lot of exempt employees who are going to be angry, who are going to feel that this is demotion, that they had ascended and got promoted into the ranks of management to the exempt status, and now they're being demoted out of management. So you need to develop, and I would suggest, written communication materials, written FAQs, written talking points, and understand how you're going to communicate, when you're going to communicate, and who is going to communicate. Is it going to be one-on-one meetings? Is it going to be an email? I think one-on-one meetings, if you have the time, is a better way to do it. And also, when you're communicating, I think you have to assure employees that this is not a demotion. You're only doing this because the government is making you. And I think a good message is our goal is to keep the deal we had, to keep your total earnings, annual earnings, the same tomorrow as they are today. And that is the goal that you're trying to accomplish. But think it out, write it out, and make sure everybody is working who communicates and talks about this to their employees are on the same page and using the same written materials to communicate the messages carefully, so you do not have a workforce which is angry. Finally, for the very same reasons as we needing to review your policies and practices, I think training employees who are now newly reclassified on your timekeeping practices, your timekeeping system, and what is work and what do they have to record, and that it's their responsibility to record all the hours they worked is a very is really, to me, highly recommended, so you can avoid those off-the-clock claims. And you should also, of course, train their managers. These managers might never before had to manage non-exempt employees and might not know much about. Guess what? You tell an employee to go and sit in a chair and sleep. That's work, right? Employees can, if the employees are told to go to sleep, they are working, and your managers need to know those intricacies of the law. With that, I think we're ready to take some questions, Randy and Mark. The only thing else I would mention is that we've designed something that we're calling the Exempt Toolkit. And what the Exempt Toolkit has is it has basically an entire reclassification plan, step-by-step directions of everything you need to do to get somebody reclassified. It has my template communication materials. It has my template policies. It has my template fluctuating workweek agreement, and we're selling that, and it comes with 4 hours. It says an hour, but it's actually 4 hours of attorney time. And Mark and Randy, we're selling that for a flat fee of $4,000. And I will say right now that if any chamber member wants to take advantage of this and get access to this toolkit, I'd be happy to give a $500 discount to chamber members.
Okay. Thank you, Tammy. As everyone can see, there's an awful lot to talk about on this regulation, and Tammy did a remarkable job of getting it all out in the time frame. We have a few minutes left. We're going to take a few questions that came in through the email web portal. I apologize for people who may be on the phone thinking they could get a question in, but right now we're going to just grab a few from the email. And to give Tammy a breath, I'm going to take care of a few of them up front that I know how to answer. So one of them says, who do I call to tell them this is a horrid rule for small business chambers and nonprofits? Great question. The answer is your members of Congress. Tammy mentioned the piece of legislation that's been introduced in both the House and Senate. It's in the slides on the PowerPoint. This is the ideal time to tell your members of Congress, and by all means, if you have Democrat members of Congress, please, please, please tell them how displeased you are about this regulation. They need to hear this more than anybody else. Second question I'm going to handle says, because this is based on an executive order, would still take place if there is a change of party in November. First part about that, this is not an executive order. This is a full-blown rulemaking. The Department of Labor has authority to do this rulemaking. We just think they did it badly. This is not an executive order. And as Tammy addressed, if there's a change of party in the next election, then there may be some opportunities to fool around with this. But I would tell you that the chance to roll back the salary threshold is probably going to be very, very limited, if at all. So I would not expect relief on that point from a change of parties in the election. Tammy, we're going to throw a few questions to you now that I'm going to read, and so hopefully you'll be able to give a couple quick answers.
Sure.
Where's the one on the 506? Right here. One of the questions that came in says, and this is one I know you've talked about before, the 501c6 organizations have to comply if they don't reach the $500,000 annual threshold.
Yep. Yeah, that's absolutely right. Now, DOL put out some fact sheets with the final regulations addressing nonprofits and trying to get you all to believe, oh, you don't have to comply because you're not commercial enterprises. And it's true that nonprofits who have less than $500,000 in commercial income and commercial revenue are not covered as an enterprise. However, almost all of your employees are individually covered, and that's called individual coverage, because they either use a product that's been shipped interstate, they use the telephone to make an interstate phone call, they get on the internet to order products. Anything that's connected with interstate commerce means your employees are covered. And in fact, I went on to DOL's enforcement database a couple days ago, and I found hundreds and hundreds of investigations against nonprofit entities. So please do not think you don't have to comply because you're a nonprofit. You still have to comply, and even if DOL decides they're not going to go after you, plaintiffs' lawyers will.
Great answer, Tammy. Here's another one. You said that the regulation does not apply to outside sales employees. Does that mean that outside sales employees can be exempt but make less than $47,500?
Yes, that's absolutely right, because the salary tests, that salary level and the salary basis test do not apply to outside sales employees. So you can pay outside sales employees 100% on commission, and there can be weeks in which they do not even earn the minimum wage, and they are still exempt under this regulation, and there's been no changes to that.
Great, thank you. Here's another one. We have employees who make $913 or more per week, but only work 9 months a year. As a result of only working 9 months, the annual salary threshold will not be met. They are not seasonal employees. Are the 9-month employees still exempt under the new regs?
Yes, they would be. I think the media talks a lot about annual salary because it's easier, and that's what we all think about when we think about our exempt employees. But the actual test in the regulation is a week-by-week test. So any week in which an employee earns the $913, they can be exempt that week. And so if you have somebody earning $920 a week and they're paid that for 9 months, for each week in the 9 months that they work, you are in compliance with the salary level, and they can continue to be exempt.
And I think this one's somewhat related, but a little bit different. How does the new rule affect permanent part-time employees that do not meet the minimum wage amount? Right. And by minimum wage, I'm going to they meant the salary threshold.
Yes, and there's no prorating on this minimum salary level for part-timers. Now at $23.60 or $4.55 a week, a lot of part-time employees who performed exempt duties could be classified as exempt. But under this new regulation, even part-timers have to earn $913 a week before they can be classified as exempt. Of course, the good news, if you're managing them to under 40 hours a week, if they're working. Well, if you got a lot of people, you're paying 29, you're letting work 29 hours to avoid the Affordable Care Act costs, then you're not going to owe them overtime anyway. But if they are paid less than $913, they are not going to be exempt. Great.
We're at about 1 o'clock right now, so I'm going to give you one more question, and then I think we're going to close it out. And this question is, does the new rule apply to businesses with under 50 employees?
Yes, it does, because this depends upon your level of revenue, not your number of employees. And so any business that has over 500,000, half a million in revenue a year is subject to this rule. So only the smallest of the smallest companies are not enterprise covered. But again, even if you're under 500,000, if you have an employee who has any connection with interstate commerce, who is purchasing or buying products that come in from other states or using product that comes in from other states, running credit cards, making interstate phone calls, using the internet, they're still going to be covered as individual employees, and it doesn't really matter how many, whether you're a 5-person shop or a 50-person shop.
Thank you. I think that question is driven by a certain amount of confusion with all the laws that are coming out these days. Some of them have 50 employee thresholds. I'm thinking of the FMLA. I'm thinking of the Affordable Care Act. And I think it's easy to get confused as to which law has a threshold and which doesn't, or what the different thresholds are. So I can imagine how people might be thinking about that for this law. With that, I'm going to wrap up, and we have a question about making these slides available. We will be emailing the people who registered with the link that they can access this, they can use to access this presentation for the next 3 months, I think it is. And you'll be able to go back and listen to this and see the slides and absorb this a little bit more on your own time. So with that, I'm going to thank everybody for being on the call and the webinar. We had an absolutely phenomenal response, especially since we only put this out yesterday morning. I think this speaks to the confusion and probably to the frustration of many people about this overtime regulation. And we appreciate your interest and participation, and we bid you a good day, and thank you for participating.
And that will conclude today's call. We thank you for your participation.